And our first guest speaker is my old friend Abhilash, who's a senior lecturer in internet law at the University of Aston in Birmingham in the United Kingdom, but he's also editor-in-chief of the European Journal of Law and Technology and deputy editor of the International Review of Law, Computers and Technology. There's a string of other titles that he's got, all of which simply underline the fact that this guy knows what he's talking about. So, Abhilash, over to you.
Thank you, John, for the very generous introduction. Stop me when 5 minutes left. Let me know. Thank you. Okay, so what we did at Aston University as the first logical step to this project was to do a mapping exercise of existing age verification requirements across all member states in the EU and the United Kingdom. So that was important to do because, we needed to understand what exactly the legal requirements are, if there are any, in terms of age verification before we start talking about developing projects or setting standards. We had about 4 months to do that, 3 months originally. We managed to negotiate a 1-month extension, so we had 4 months to do that. So it was a rapid review of various laws. So it was quite an enormous task to be undertaken in a short period of time. So essentially, the main objective of our study was to obtain an overview of the existing AV requirements found within the legal framework across EU member states and the UK. We approached that by grouping the laws into 3 broad categories, including online content as envisaged under the AVMSD, online services, specifically focusing on the laws that apply to gambling, and the online sale of age-restricted goods, with a specific focus on the sale of alcohol and tobacco. So the research questions we addressed in the study are as follows. To what extent have EU member states and the UK transposed the AVMSD into their national systems? And more importantly, stemming from that, what are the current legal requirements in relation to age verification to protect minors on on-demand services and video sharing platforms? And like I said before, what are the key requirements for gambling, tobacco, and alcohol found in the national laws in different member states and the UK? We also posed the question of the age at which a child can consent to the processing of personal data as envisaged under the GDPR, and obtained an overview of what the state of play across different countries. I won't spend any time over the AVMSD itself. People who are old enough in this room will know the Television Without Frontiers Directive dating back to 1989, which was revised once in 2020 due to the changes in technology, the changes in which content was accessed, and which underwent further changes to recognize the newer methods or newer delivery channels through which people access content, especially children. So it was extended to cover video sharing platforms in 2018. I'll very briefly talk about the requirements in the AVMSD. June has already talked about the fundamental principles of which. Like I said before, the scope of the directive was extended to reflect the shift in the media landscape. People tend to access content more and more on video sharing platforms rather than the traditional TV or on-demand services, which used to be the case back in 2010, or just before 2010. Now, this is a significant change from a legal perspective because typically video sharing platforms do not exercise any editorial responsibility or controls, and yet the new AVMSD required them to implement necessary measures to protect minors from harmful content. Article 28B is a relevant provision. The directive sets minimum standards, like directives should do, that member states are required to adopt. However, like most directives, there are exceptions, there are discretions offered to member states in terms of implementing rules, so long as they do not violate the golden principles of the e-commerce directive and the Charter of Fundamental Rights of the EU. The country of origin principle has been kept, which means the providers are only obliged to comply with the laws of the country they are deemed to be established. Again, there are derogations that can apply where content is targeted to a particular jurisdiction outside where the company is based. There are also other provisions within the AVMSD which require media service providers to provide information that can assist parents or children. For example, labeling or age ratings, so on and so forth, which again, we did not look at it into very much detail, but nonetheless is a pertinent thing to mention. Article 28B is perhaps the most important among the amendments revisions made to the AVMSD in 2018 by bringing video sharing platform providers under their remit to take appropriate measures to protect children from programs or user-generated videos that may impair their physical, mental, or moral development. So the principles are pretty much the same, except that it's been extended to video sharing platforms as well. Now, the article also specifically states that lists the number of measures that may be appropriate depending on the severity of the content, of the degree of harm that the content may inflict, for want of a better word, on its consumers, which includes establishing and operating age verification systems, but also establishing and operating easy-to-use systems, allowing users to rate the content, but also providing for parental control systems that are under the control of the end user with respect to content which may impair the physical, mental, or moral development of minors. And this essentially reflects that the idea is not to assume that all content is harmful. The idea is that there are different degrees of harm, different degrees of inappropriateness stemming from different types of content, and each merits separate responses or different proportionate responses. There is a close relationship between the AVMSD and the GDPR in the sense that personal data of minors collected or generated in order to comply with the measures to protect minors from harmful content must not be processed for commercial communication purposes, such as direct marketing, profiling, and behaviorally targeted advertising, which is very much in line with the general data protection regulation principles, such as data minimization, purpose limitation, fairness, and so on. Okay, so that being a broad overview of the laws, we'll talk about our research findings, specific research findings based on the rapid review. Like June mentioned earlier, not all countries have transposed the AVMSD despite the deadline passing in September of last year. As of June 2021, there were 10 countries who have yet to transpose the AVMSD within the EU into their national legal system. One other thing we found, and it's quite interesting to note, is that there was no harmonization as to the scope and definition of what constitutes harmful content that could impair the physical, mental, or moral development of children across member states. And that is not surprising because often, save for the clearly legal content like child sexual abuse material or terrorism material, a lot of content that fall within the classification of lawful for adults but maybe inappropriate for children is hard to define, and it is intrinsically linked to prevailing standards of each society, norms, and what each society considers to be appropriate. And that also changes with time. So, for example, what we regarded as inappropriate in the 1960s or 1970s may be acceptable now, and you can see that not just in relation to content, but also certain conduct as well. So it's difficult to obtain 100% harmonization across member states as to what specifically would constitute in terms of defining what exactly would be harmful content for certain categories of material. Okay. For video sharing platforms, again, the directive leaves it up to individual member states to ensure that platforms within their jurisdiction comply with the requirements. Not all countries have a video sharing platform operating within their jurisdiction, and that means that very little has been done in many jurisdictions in terms of doing anything about it. One other thing worth mentioning here is that what exactly constitutes a video sharing platform. There is also, it's likely to be a bit of lack of consensus between member states, among member states from the EU perspective, because it's up to the regulators, individual member states, to identify and define who are video sharing platforms. And although the EU has given some helpful guidance, terminology like essential functionalities, if a platform's essential functionality is that of the provision of audiovisual media services, or if there are video services involved, then it could still be regarded as video sharing platform. And when we engage with regulators, we ask the question, would you consider a platform like a social media site like Twitter to be a video sharing platform? And there were different divergent views that we obtained from that consultation. And in one way, you could argue that we're on a site which allows 140 or 280 characters, which also allows sharing of video files. Could that not be then classed as an essential functionality of Twitter? But that's not universally received when we spoke to different stakeholders from across the EU. Most countries don't have any specific guidance on how age verification tools should be implemented in practice, and that's partly because of what June said earlier, that this is not intended to be a prescriptive directive. But nonetheless, there are some countries where regulators have issued helpful guidance, age verification criteria or guidance to be adopted, which users have found particularly helpful. In terms of gambling, all jurisdictions impose a minimum age requirement to participate in gambling to protect children. And it is one of the better regulated sectors, as has already been raised earlier. 24 jurisdictions have adopted 18 as the limit for all types of online gambling. In other jurisdictions, including Belgium, Estonia, and the UK, the age limit can range from between 16 to 20, depending on the type of gambling activity. Greece has adopted a 21 age limit for all types of gambling across the board. Most countries require not just age verification, but also for identity registration for online gambling. And that's not just to protect children, but there are also other considerations, for example, to protect vulnerable adults from gambling addiction, so on. Moving on to the online sale of age-restricted goods, alcohol and tobacco. Alcohol, again, age limit varies between 16 to 20 in the EU. Most countries have adopted 18 as the limit to purchase alcohol, but some countries, the age limits very much depends on the alcohol content in the beverage. I'll just gloss over that because the point has been made. Same with the tobacco. Member states have adopted 18 as the legal age limit for the sale of tobacco and tobacco-like products. Again, very few countries have offered any specific guidance on age verification tools itself for the sale of age-restricted goods online. Although there are some good practices, for example, UK and Malta require age verification systems to be implemented for the cross-border sale of tobacco. Germany has indicated that under the guidelines that entering an ID number to verify the age of the user is not deemed sufficient and additional measures must be implemented. So, in terms of child's and parental consent, again, the list was pretty much as expected. There are some countries like Belgium, Denmark, Latvia, Estonia, Finland, Malta, Portugal, Sweden, and UK have stuck to the 13 age limit. On the other end, Croatia, Germany, Hungary, Ireland, Slovakia, Poland, Netherlands, and Luxembourg have stuck to the 16-year limit as envisaged in the GDPR. My final slide. In terms of the additional findings, apart from the individual slides I talked about here, we thought that having looked at the laws and how it operates in these different member states, we thought that the technical measures adopted must be proportionate to the potential harm of the program or of the content. The law does not envisage all content to be subject to age verification. The measures adopted to protect children, whether it's age rating or labeling, or age verification tools that provide higher levels of assurance, should depend very much on the content and the risk of harm that it may cause. And effective regulation cannot be achieved by enacting laws alone. It's not because of want of sufficient legislation that we find ourselves in the position that we are at the moment. Legislation is only the first step. For the laws to work, it also needs to have an effective enforcement mechanism. That's where good age verification solutions might be worth considering. Now, this also has been raised earlier. Age verification is not a silver bullet. It's not a substitute for responsible parenting or legislation or the safeguards that are currently in place to protect children. But nonetheless, it has a vital role to play in effectively implementing the current laws, protecting children from harmful content, online services and products. But a final point, perhaps the most important point, is that age verification solutions should respect children's rights. When I say children's rights, that's not just as envisaged under the GDPR or the AVMSD, but the wider substantive rights of children as enshrined in the UN Convention on the Rights of the Child. And they should be privacy preserving, not with respect to children, just with respect to children, but also with respect to adults. Thank you.
Thanks very much, Abhilash. We're going to do questions